So, you're thinking about taking your business across borders? That's awesome. It's a huge, game-changing move. But, before you take that leap, you really need a plan. So think of this as your essential legal roadmap. It's going to help you navigate all the opportunities and, yes, the challenges of going global.
Right, so the big question is, are you really ready? Because expanding internationally isn't just about finding new customers. Nope, it's about stepping into a whole new world of rules, regulations, and, let's be honest, risks.
The good news is, you don't have to go in blind. International law isn't some big barrier meant to stop you. It's more like a terrain, a landscape. And with the right map, you can absolutely navigate it. Okay, let's get into it.
Our very first checkpoint on this journey is just understanding the terrain itself. Before you make any moves, you have to know the lay of the land, and that is the global legal landscape.
I just love this analogy. Think of it like this. International law gives you the basic grammar that pretty much everyone agrees on. But when you actually land in a specific country, you've got to learn its unique local dialect, its own domestic laws, if you want to do business there effectively.
Okay, now this is where it gets really interesting, because you're going to run into one of two major legal systems. In common law countries, like the US or the UK, what's written in the contract is king. The exact text rules. But then you go to a civil law country, think most of Europe or Japan, and it's a different ballgame. The law comes from these big legal codes, and courts will actually look past the words on the page to the good faith intent of the deal. That's a huge difference, and it can totally change how your contracts are enforced.
All right, moving on to our next checkpoint. So if the legal landscape is the terrain, then a really well-crafted international contract, well, that's your all-terrain vehicle. It's what's designed to get you to your destination safely. And one of the most critical parts of that vehicle is understanding something called Incoterms. These are basically a universal shorthand for shipping, a set of standard terms that everyone agrees on. They just wipe out any confusion by clearly stating who's responsible for what at every single step of the shipping journey.
This shows you the whole spectrum perfectly. On one end, you've got EXW, where the seller's job is pretty much done the second the goods leave their warehouse. Easy for them, right? But on the total opposite end, you've got DDP, where the seller handles absolutely everything until it's at the buyer's front door. Choosing the right one is a really strategic move. It's all about balancing cost, control, and risk.
Okay, checkpoint 3. As you start moving into these new markets, you're not just carrying products. You're carrying your brand, your inventions, your creative work. All of that is your intellectual property. It's the treasure of your business, and you have got to protect it. So here's your IP toolkit. You've got trademarks for your brand, patents for inventions, copyrights for creative stuff, and trade secrets for that, secret sauce. But here is the number one thing that trips people up. IP rights are territorial. That means protection in your home country does not automatically follow you around the world. And that brings us to a pretty serious warning. If you fail to protect your IP abroad, you can fall victim to something called trademark hijacking. That's when somebody else swoops in and registers your brand name in a foreign country before you do. This is the stark reality in so many countries. It is not about who used the brand first. It's about who filed the paperwork first. That's it. And believe me, this isn't just a small business problem. We're talking about giants like Tesla and Starbucks, who've had to fight these incredibly expensive legal battles just to get their own names back. The lesson couldn't be simpler. Register your trademarks in your target markets before you even think about entering them.
Every journey has its tolls. In the world of international business, those tolls come in the form of taxes. So our fourth checkpoint is all about understanding those cross-border tax rules so you don't get hit with any nasty surprises down the road.
A really critical concept you have to get your head around is transfer pricing. This is simply the price your company in, say, country A charges your own branch in country B. Tax authorities watch this stuff like a hawk to make sure you're not just moving profits to a country with lower taxes. The big rule they enforce is called the arm's length principle. Basically, the price has to be fair, as if you were dealing with a totally separate company.
And if you think this is just some minor technical thing, let's take a look at what happened with a global giant. The case of Samsung in India is a really powerful example of what happens when transfer pricing goes wrong.
So what happened was, Indian tax authorities looked at the royalty fees Samsung India was paying back to its parent company in Korea. They basically said, hey, wait a minute, that price isn't fair market value. It looks like you're just trying to lower your tax bill in India. The whole thing ended up in court, and Samsung had to pay up. So the lesson here is crystal clear.
Get your pricing right and document exactly how you landed on that price. All right, our final checkpoint. This one deals with the inevitable, the detours and the bumps in the road. When you're dealing with different cultures, different laws, different expectations, disagreements are just bound to happen. The real key is knowing how to solve them efficiently.
So when a dispute happens, sure, you could go to court. That's called litigation. But look at this. The overwhelming favorite for international business is arbitration. And why is that? Well, it's usually faster, it's confidential, so your business stays your business, and you get to pick a neutral expert instead of being stuck in a foreign court system.
And here's the kicker. Here's what gives arbitration its real teeth. There's this treaty called the New York Convention, and it means a decision made through arbitration in one country can be legally enforced in over 160 other countries. This makes it a really practical, powerful tool. It means that when you win, you can actually collect. So, let's wrap up our journey with a final checklist, shall we? First, know the legal system you're walking into. Second, be crystal clear in your contracts using tools like Incoterms. Third, protect your IP before you go. Fourth, document your transfer pricing. And finally, plan for disagreements by putting an arbitration clause in your contracts. Seriously, following this map is going to save you an incredible amount of time, money, and headaches.
Look, the global market is just brimming with opportunity. And yeah, navigating the legal side is challenging, but it's not impossible. It just takes a good plan and the right knowledge. So, with this map in your hand, the only question left is, where will your business go next?